We are on the record in the Ansell matter, case D15-521-960D. Please confirm your appearances.
Good afternoon, Your Honor. Marshal Wilk 2515 for Irene Ansell, who is not here by court direction.
Good afternoon, and I believe we have Mr. Jones on the phone. Can you hear us, Mr. Jones? Can you confirm? Hello? Mr. Jones, can you hear us? Hello?
Hello? Hello? Hello? Hello? Hello?
Right, okay, I'm going to connect you back here.
All right, we are on the record in the Ansell matter. Mr. Jones, can you state your appearance?
Yes, John Jones, bar number 6699, appearing on behalf of the defendant.
Okay, good afternoon. And you don't have any problem hearing?
No, I can hear you, Your Honor.
Okay. All right, and I have a statement prepared that I'm going to read, and at the conclusion of my reading, that'll be the end of the hearing. This case has a long and tortured history. Both parties, and I emphasize both parties, should clearly understand my feelings about their conduct throughout these proceedings. Both parties, and counsel I might add, have a tendency to look at the glass half empty. In this regard, both sides have expressed unhappiness with orders issued by this court and disagreement with recommendations made by Mr. Roston. Whenever anything is not right in line with what either party requests, there is an almost knee-jerk reaction to claim bias or that the fix is in. Rarely do I hear counsel acknowledge in a positive fashion the orders that benefited their clients. Those quickly fade from memory, and the court is instead reminded of what the court hasn't done. The narrative has spewed that this court allows the other side to get away with crap. As I look at the history of the parties' relationship, they initially embarked on a path that included the signing of a premarital agreement and fervent negotiations thereafter, whereby Ms. Ansell sought to protect the party's daughter from Mr. Ansell, and Mr. Ansell sought to protect his wealth. At that time, Mr. Ansell had absolutely no hesitation negotiating away his parental rights. By way of the pleadings on file, Ms. Ansell requested sole legal and sole physical custody of the party's daughter. By way of the pleadings on file, Mr. Ansell requested joint legal and joint physical custody of the party's daughter. The court's order based on the evidence admitted into the record, which perhaps has been lost in the translation of how this case has progressed, was joint legal and joint physical custody, precisely what Mr. Ansell had requested in his pleadings. Every aspect of this case has confirmed the propriety of such an award, including the fact that I cannot trust that either party would not abuse the title of primary physical custodian as a title of power and control as opposed to a mantle of responsibility. I previously had believed that the most important issue in this matter was the custody of the party's daughter and protecting her best interest. In retrospect, after months of haggling over money, perhaps I was mistaken. If Mr. Ansell ever complains to anyone about what he perceives as crap coming from this court, he needs to be reminded again and again and again that the one issue that this court previously had believed was the most important and was of most significance, he was awarded exactly what he requested in his pleadings. The purpose of setting today's hearing today is to disclose what this court perceives to be efforts to influence this court outside of this courtroom. In my 25-plus years of experience in both private practice and sitting as a judge, I've never been involved in a hearing like this. I'm not looking for any orders to be drafted from this hearing. There are no findings of fact to be prepared and no orders to be issued. I'm not entertaining any discussion, nor will I be answering any questions. The only influence that either party should have on this court is what happens within this courtroom. Our system of justice depends on and indeed requires the maintenance of the integrity of the court as a whole. This is not just about me or about this case. Our entire system depends on the exclusion of outside influences. Something much larger is at stake, and anyone who attempts to undermine this integrity corrupts the process. Indeed, we should all be frightened and alarmed when any effort is undertaken to influence any tribunal outside of any courtroom. Counsel, as officers of the court, have a duty to ensure the integrity of the administration of justice and to counsel their respective clients accordingly. I adhere to the notion that complete transparency is integral to the preservation and protection of our judicial system. For this reason, I am generally averse to conducting any hallway discussions. Similarly, as counsel are aware, I'm in the courtroom and on the record for UCCJ telephonic conferences as well as telephone hearings. That does not mean that everything must be on the record. There are occasions in which both counsels seek direction from the court and prefer to have the discussion off the record. But even in those occasions, it takes place in the courtroom. As a general matter, I believe discussion should be on the record, except in very rare instances. Thus, we are on the record. Because of the nature of this hearing, however, I'm limiting appearances to counsel for both parties. At our prior hearing in April, I disclosed on the record that my ecclesiastical leader was present in the gallery of the courtroom. He also has submitted an affidavit, which I have not read. For sake of additional transparency, I felt it appropriate to discuss the nature of my relationship with Mr. Tashima. I currently serve as a bishop in a young single adult ward that is comprised of congregants generally between the ages of 18 and 31. A ward is a descriptive term that is defined by a geographical area. Members of our faith attend religious services that are defined by their geographic boundaries, or wards. Generally, between 8 to 10 wards make up what we call a stake. Again, a stake covers a particular geographic area and oversees the wards within its boundaries. Mr. Tashima is my stake president. Thus, as the bishop of a ward in the stake, I report directly to him. Now, at no time has Mr. Tashima ever discussed this matter with me or mentioned Mr. Ansell, nor do I believe he ever would. I stated that fact at the April hearing, and that remains true today. It is my understanding that Mr. Ansell hired Mr. Tashima as his CFO. I have known Mr. Tashima for years and consider him to be one of the most honest and trustworthy people I know. Thus, if he were to offer a statement or testify in court, I believe his word and trust what he states under oath is the truth. Again, I emphasize that Mr. Tashima has not communicated with me in any fashion regarding this case outside of court, and I don't believe he would do so. The mere fact that Mr. Ansell has hired Mr. Tashima does not affect my ability to adjudicate this case. For sake of complete transparency, however, plaintiff is entitled to know that I would, at least as a starting point, find that what Mr. Tashima tells me in a court to be credible because I hold him in such high esteem. I can appreciate the fact that plaintiff would view defendant's hiring of my stake president as understandably suspicious. I similarly would understand if plaintiff chose to file a motion to have me recused from the case. And although I personally have no desire to remain involved in this case, I recognize my fundamental duty to sit. Thus, I do not voluntarily recuse myself from this case. My relationship with Mr. Tashima and his hiring by Mr. Ansell is not what gave rise to today's hearing, except to the extent that I felt it was important for transparency purposes to describe in greater detail the nature of our relationship. That being said, and as I noted before, I recognize the natural suspicion that would arise for Ms. Ansell, who previously has testified that she believes that Mr. Ansell would do whatever it takes to influence this court, including outside influences. I also recognize that these facts and circumstances would cause Ms. Ansell to question any decision by this court and to wonder whether there has been any influence beyond the four walls of this courtroom. For this very reason, I scheduled this hearing to disclose recent events for the sake of maintaining complete transparency. Within the past week, while carrying out my ecclesiastical functions, I've been exposed to a random comment from a congregant from a different ward, again, not the ward I preside over, that, quote, Doug Ansell is a great guy, close quote. After cringing from hearing this out-of-court statement, I told this individual that I cannot talk about the case. There were no specific facts offered about this case, and nothing else was said. I understand that this simple communication may seem innocuous and innocent. No information was disclosed, but there was an obvious message to be conveyed. My response to such a comment is to be more cautious and critical of my approach to the case. Indeed, the effect of such a communication is the very opposite of what was perhaps intended by the person making the comment. I am averse to anything like this. I will reveal this communication on the record again today for purposes of transparency. Also, within the past week, I received a communication from Mr. Steve Sanson requesting that I call him. Over the past 9+ years, I've spoken with Mr. Sanson on occasion, appeared on his internet program on one occasion, and have chatted with him at various functions. I've been told that from time to time he has written scathing materials about colleagues of mine. I even heard recently that he had declared war on the family court, and I mentioned that to him the last time I saw him. Although our communications are neither routine or common, they have been cordial and never involved a pending matter before me. Thus, I had no reason to believe that his request to talk to me would be any different. During our brief telephone conversation, however, Mr. Sampson asked me why I allowed Marshall Willick to get away with so much crap in Doug Ansell's case. Immediately shocked beyond belief that a pending case was even brought up by someone I had trusted knew better, I immediately told Mr. Sampson that I could not talk about the case, and I ended the call immediately. To be clear, nothing specific from a factual standpoint was discussed in this telephone call. Nevertheless, for purposes of complete transparency, I directed my staff to immediately set a hearing to discuss this attempt to influence the court with a private out-of-court statement. Mr. Willick and Mr. Jones have a duty, as officers of the court, to assist this court to ensure the administration of justice without outside influence. I can say with a relative degree of certainty that neither Mr. Willick nor Ms. Ansell communicated information to Mr. Sanson about a sealed file and put him up to communicating with the court in an effort to influence this court. I'm similarly confident that Mr. Jones did not do so either. Any attempt to influence or sway this court's decision outside the four walls of this courtroom should be frightening to counsel and corrupts the administration of justice. This must stop right now. It is incumbent upon Mr. Jones to bring some sanity to this case by controlling his client's efforts to influence this court outside of this courtroom. We will last hear in court on April 19th. An order to show cause has been issued and is set for hearing on May 31st. Trial of the financial issues is set to be heard on June 23rd. Although I had not planned to discuss the status of the forensic valuation services being conducted by Mr. Roston today, I received a disturbing report from Mr. Roston yesterday that has been e-filed and disseminated to the parties. Sadly, it appears that Mr. Roston has been subjected to name-calling and accusations of bias. Efforts to influence Mr. Roston improperly appear to be in full swing. I remind both parties that they jointly agreed to Mr. Roston. Apart from his appearances in court in this case, I have no interaction with Mr. Roston. Both parties have expressed disagreement with aspects of his report. Both parties pick and choose those parts they agree with and dispute what they disagree with. I am troubled and concerned by Mr. Ansell's communications with Mr. Roston, and I am concerned that the trial dates are in peril. Again, Mr. Jones is urged to bring sanity to this case by exerting control over Mr. Ansell and to see to it that the report is completed timely. At the last hearing, I gave Mr. Ansell an out in an effort to facilitate the completion of this case. Recognizing that Mr. Ansell clearly owes Ms. Ansell several months of support, I gave him a mechanism to purge his contempt by utilizing the money he owes to Ms. Ansell to satisfy the amounts owed to Mr. Roston. In this way, Ms. Ansell was effectively contributing to the cost of the evaluation, and Mr. Ansell was purging the contempt. If he did so, I clearly stated that I would not view the May 31st hearing as a contempt hearing. Plaintiff was understandably not pleased that I would give Mr. Ansell an out by using Ms. Ansell's support money to pay the expert fees. Indeed, Mr. Willick has argued, but in different terms, that I've allowed Mr. Ansell to get away with crap and that allowing Mr. Ansell to use Ms. Ansell's support money to pay expert fees was crap. It is time to bring this matter to a close and for Mr. Ansell to step up and seize the opportunity I gave him to purge his contempt. There should be no conditions placed on his payment of fees to Mr. Roston. If Mr. Ansell has failed to do so by the time of our May 31st hearing, counsel should direct him to bring his toothbrush with him. That concludes our hearing.